Judgment in the matter of Sharp Corp Ltd against Viterra BV.
Lord Hamlin will hand down this judgment.
This is a summary of the decision of the Supreme Court in this matter. The background. This case involves an appeal and a cross-appeal. The appeal concerns the jurisdiction of the court on appeals from arbitration awards under the Arbitration Act 1996, which I shall call the Act. The cross-appeal concerns the proper approach to the assessment of damages under a standard contract form of the Grain and Feed Trade Association, or GAFTA. The appeals arise out of appeal awards relating to cost and freight free-out, or C&FO, Mundra sales of pulses by the appellant seller, Viterra BV, who I shall call the sellers, to the respondent buyer, Sharp Corporation Limited, who I shall call the buyers. The GAFTA Appeal Board found that the buyers were in default by their failure to pay for the goods in accordance with the terms and conditions of the contracts, and liable to pay damages based on the estimated value of the goods on the date of default, under Clause 25 of GAFTA Form Number 24, the Default Clause. At the date of default, the goods, which had been shipped from Vancouver, had been discharged at Mundra, customs cleared and stored in a warehouse. They had increased in value as a result of the imposition of import tariffs, subsequent to the customs clearance of the goods. The Appeal Board held that the estimated value of the goods was to be assessed on the basis of the theoretical cost on the date of default of buying the goods free on board, or FOB, at the original port of shipment, plus the market freight rate for transporting the goods from that port to the discharge port free out. The damages awarded to the sellers were some US dollars 4.16 million and US dollars 900,000 under the two contracts. The buyers obtained permission to appeal in relation to how damages under the default clause are to be assessed, quote, where goods sold C&F free out are located at their discharge port on the date of the buyer's default. It was the buyer's case that they should be assessed on an as-is, where-is basis, being the estimated ex-warehouse Mundra value of the goods. Mrs. Justice Cockerill dismissed the buyer's appeal. The buyer successfully appealed to the Court of Appeal. However, in reaching its decision, the Court of Appeal amended the question of law for which permission had been given, and held that damages should be awarded on the basis that the contracts had been varied, as to which there was no finding by the Appeal Board. The sellers now appealed to the Supreme Court on the grounds that the Court of Appeal exceeded its jurisdiction. The buyers cross-appeal on the basis that if the appeal succeeds, damages should be awarded on an as-is, where-is basis. In its judgment, the Supreme Court unanimously allows the appeal and also allows the cross-appeal. The awards are remitted to the Appeal Board for reconsideration. I give the judgment with which all the other justices agree. The reasons for the judgment. The appeal. The first issue is, did the Court of Appeal err in amending the question of law for which permission to appeal had been given? The Court of Appeal amended the question of law by adding the words, quote, in the circumstances found by the Appeal Board in the awards. Amendments to the question of law are permissible, provided that the substance of the question of law remains the same. In this case, the question of law was framed in abstract terms, and the effect of the amendment is to tie that generally expressed question to the facts found in the awards. That is a permissible amendment. The amendment was expressly stating what is implicit in any arbitration appeal. It did not change the substance of the question of law. The second issue is, did the Court of Appeal err in deciding a question of law which the Appeal Board were not asked to determine and on which it did not make a decision? Under Section 69(3)(b) of the Act, appeals may only be made on a question of law which, quote, the tribunal was asked to determine. This requires that the point of law be fairly and squarely before the tribunal for determination. The Court of Appeal's decision on damages was premised on a finding that the contracts had been varied. The question of whether, and if so how, the contracts had been varied was neither argued before nor addressed by the Appeal Board. It follows that this is not a question of law for which permission to appeal could be given under Section 69 of the Act, and if so, it is not open to the Court of Appeal to introduce such a question on an appeal. The third issue is, did the Court of Appeal err in making findings of fact on matters on which the Appeal Board had made no finding? The Court's jurisdiction under the Act is limited to appeals on a question of law. It has no jurisdiction to make its own findings of fact. Whilst there may be circumstances where it is possible to infer that the tribunal has made a finding of fact, even though it is not expressly set out in the award, these circumstances are limited. It is necessary to show that the inferred finding is one which inevitably follows from the findings which have been made. The Court of Appeal's conclusion that the contracts had been varied relied on a finding which it made that discharge was against presentation of the original bills of lading. That is a finding of fact. It was not relevant to any issue addressed by the Appeal Board, and it by no means inevitably follows from the findings of fact which the Appeal Board made. It follows that the Court of Appeal impermissibly made a finding of fact on a matter on which the Appeal Board had made no finding. The appeal is therefore allowed. The cross appeal. Damages fall to be assessed under the default clause. This clause reflects both the compensatory principle and the principle of mitigation of damages. In accordance with the principle of mitigation, if a substitute sale or purchase is reasonably made, then that is likely to be the default price under the default clause. If, as in this case, there is no relevant substitute transaction, then damages are assessed under subclause C on the basis of, quote, the actual estimated value of the goods on the date of default. This subclause covers the same territory as sections 50 subsection 3 and section 51 subsection 3 of the Sale of Goods Act and the common law, which means that where there is an available market, the normal or prima facie means of establishing the actual estimated value of the goods is by reference to the price of a substitute sale or purchase in that market. In the present case, there was no evidence before the Appeal Board of an available market for a substitute transaction on C&F FO Mundra terms. In such circumstances, the sellers contended that damages should be assessed by reference to the FOB Vancouver market, with appropriate adjustments being made to arrive at a C&F FO Mundra price, as the Appeal Board accepted. The buyers contended that it should be by reference to the ex-warehouse Mundra market. The proper approach is to be guided by the principle of mitigation, and to consider the markets in which it would be reasonable for the seller to sell the goods. On the date of default, the sellers were left with goods which were landed, customs cleared, and stored in a warehouse. The goods had significantly increased in value because of the imposition of import tariffs. In such circumstances, the obvious market in which to sell the goods, and in which would clearly be reasonable to do so, was the ex-warehouse Mundra market. It is difficult to see how it could be reasonable to sell those goods in the international market, involving, as it would, the cost of re-exporting the goods and losing the increase in value resulting from the goods being customs cleared before a significant increase in tariffs. This approach is supported by the following considerations. First, the common law approach to damages for non-acceptance in CIF contracts. Secondly, where goods are left in the seller's hands, the question is what reasonable steps should be taken to sell those goods. Thirdly, it means that subclauses A and C of the default clause are interpreted and applied in a consistent manner. Fourthly, it is consistent with the compensatory principle as it brings the benefit of the increased value of the goods left in the seller's hands into account. And fifthly, it is consistent with the findings made by the Appeal Board relating to other aspects of damages. It follows that the Appeal Board erred in law in its assessment of damages. The answer to the question of law is that the value of the goods under paragraph C of the default clause falls to be assessed by reference to a notional sale of the goods in bulk ex-warehouse Mundra on the 2nd of February 2018. The cross appeal is therefore allowed.